Constructive versus actual possession in Indiana. What's the difference? We're going to talk about constructive versus actual possession, what it means, what the difference is, and we're going to try to explain it. So basically, this video is going to go over what the legal difference is between actual and constructive possession. So why does it matter? Why does it matter what kind of possession it is? Why does it matter what the definition is? This can really make the difference between a conviction or a dismissal or a finding of not guilty at trial. So actual possession is really easy. Most people, it's very easy for them to understand. So I've got a pen. I'm physically holding it. It's in my hand. I have actual possession of this pen. Now, if this was, let's say, a bag of methamphetamine and it was in my pocket and this is my suit jacket, I'm in actual possession of it. Let's say it's in my pants pocket. I'm in actual possession. It's on my person. It's in my hand. That is what actual possession means. So if the police stop you, they perform a search and they do a pat down and they find drugs in your pocket, you are in actual possession of those drugs. And that becomes very difficult to fight a trial or to try to negotiate if we're saying those weren't your drugs. On the other end is what we call constructive possession. And what constructive possession means is that you're not physically holding it, but you have dominion and control over the item. And generally here, the person has to be aware of the presence and have the intent and ability to maintain control. So the common example, let's say drugs are found in your car, let's say in the glove box. In that example, are the drugs in your hands? No. Are the drugs in your pocket? No. However, if that's your car and the drugs are in the glove box and you're the only person in the vehicle and you've got the keys to the car, so you can maintain dominion and control over the car and you have the ability to do so because it's your car, then that's going to be a case where, while yes, that is constructive possession, it's not going to be a big leap for the jury to say, well, they're your drugs. You were constructively possessing. Versus on the other hand, let's say you're in a friend's car. Please pull your friend over. And again, please perform a search and in the glove box, there's 5 pounds of marijuana. And your friend says, well, that's all your marijuana. Well, there, the constructive possession becomes a lot more difficult because the state is going to have to prove that you knew about those drugs that were in the glove box, that you had the ability to maintain dominion and control over those drugs that were in the glove box. But there, it's not your vehicle. So how did you have the ability to maintain dominion and control over it? And again, because it's not your vehicle, how can we prove that you would have known about those drugs? This is where constructive possession becomes a lot more difficult, and it becomes very difficult for prosecutors. And on the flip side, it allows defense attorneys that know what they're doing to really be able to challenge whether or not you were possessing something. So what is the legal significance in Indiana between constructive versus actual possession, and how do courts treat both types of possession? So the burden is always on the prosecution, and in constructive possession cases, the state must prove more than just proximity. And what that means is effectively the state can't just say that because you're close to something that you knew about it, you could have maintained control over it. And again, this is another example. Let's say you're at a house party. There's 100 people at this house party. The police come into the house party, and in this house party, they find a bunch of drugs in one of the bedrooms upstairs. Well, you were in proximity to those drugs if maybe you were in the living room having some drinks. But just you being in proximity does not mean that you're in constructive possession of those drugs. So that's why the state has to prove more than just proximity. Additionally, if you were in that house and it's not your home, but you were in the house and maybe upstairs where the drugs are found, you're in the bedroom. Maybe even when police bust in, you've got some of the drugs in your hand. Well, now the state might have a much stronger case for constructive possession, or potentially in that scenario, they could say this was actual possession. So that's why there's real life implications here, because so often we'll get the question, people call us, how can I get charged even when the drugs weren't on me, or even when the gun wasn't on me, when these items that maybe you're not legally allowed to have, when they weren't on your physical person? How is it possible that the state is charging? And this can really impact defenses, especially in multi-occupant settings. So if you have roommates, or there's multiple people in the car, or you're in an area that has multiple people in it, this can really change what kind of defense strategy you can make at trial. So what are some practical tips for these charges, whether constructive or actual? What do you do if you've been charged? Well, first, is the state saying that this is actual or constructive possession? Remember that mere presence isn't enough for conviction, right? So you just merely being present somewhere that paraphernalia is found, that is not enough for a criminal conviction. So possession isn't always what it seems. And that's why it's important to know your rights, and it's important for you to have attorneys that understand the difference between actual and constructive possession, and attorneys that have taken these cases to trial specifically with constructive possession, and they know what kind of arguments are going to be successful. So remember, just because you're charged doesn't mean you're guilty. And here at the Marc Lopez Law Firm, we know what we're doing. We are experienced in these kind of issues. We know the difference between actual and constructive possession, and we are more than prepared to help support you and fight for you as your attorneys. So if you've been charged with a crime, call us at 317-632-3642. And remember, always plead the fifth.